Leave the beneficiary box blank on a $300,000 IRA, and here is what can happen. Your custodian may not send it to your spouse. It can follow the default written into your account agreement instead, straight into probate, exposed to your creditors, and taxed out on a 5-year deadline if that account lands with your estate. Not always. Not for every account. But for a lot of IRAs, and for some employer plans depending on the plan document, that is the real default sitting inside fine print you may have signed decades ago. Your will usually cannot override it. One form, a form you might not even remember filling out, decides who actually gets that IRA, that 401k, that bank account, ahead of the will your attorney charged you good money to draft. This is fixable, but only if you know where to look. I am your guide to the paperwork that actually decides where your money goes after you're gone. I don't want your family finding this rule out at the funeral home or in a probate courtroom. In the next 15 minutes, what happens the moment the box is empty? The Supreme Court rule that can still pay an old 401k to your ex-spouse, and the account transfer that wipes out a beneficiary form nobody remembers signing. This is not a one-account risk either. Every retirement account, every life insurance policy, every payable-on-death bank account you own runs on some version of this same rule. If even one of those forms is blank, wrong, or decades out of date, that account can skip your spouse and your kids entirely and go exactly where the fine print says, not where you meant it to go. Here is the number that should worry you most before we go further. Under IRS Publication 590B, when an estate ends up as the beneficiary and the account owner dies before what the IRS calls their required beginning date, the entire account has to be emptied and taxed within 5 years, not stretched over a spouse's lifetime, not spread out to manage the tax bill. 5 years, full stop, whenever that specific condition applies. Quick favor before we get into exactly how that happens. If paperwork like this is the kind of thing that actually protects your family, tap like and subscribe now, so the next one finds you before you need it. Part 1. Why your will never had a say in the first place. Most of what you own falls into one of two buckets: probate assets, which your will actually controls, and contract assets, which pass by a signed agreement between you and whoever holds the account. Your IRA, your 401k, your life insurance policy, and most bank or brokerage accounts set up with a transfer on death or payable on death designation are all contract assets. The custodian, the bank, the brokerage, the insurance company, has a legal obligation to pay out to whoever is named on that beneficiary form the day they receive a death certificate. Your will doesn't factor into that payout instruction at all. They don't consult it, and legally, they don't have to. That is why an estate attorney will tell you the will is often the least powerful document in a retiree's estate plan. It only governs what's left over, the assets with no beneficiary form attached to them at all. For a retiree holding a home, an IRA, a 401k, and a life insurance policy, that leftover pile can be smaller than you'd think, which means the beneficiary forms are doing almost all of the real work in the background, whether you've looked at them in 20 years or not. Part 2. What actually happens when the box is empty? If you never named a beneficiary, or if every beneficiary you named has already died and you never updated the form, the custodian doesn't guess. It falls back to a default written into the account agreement, and for many IRAs and 401ks, that default is your estate. Once the account becomes part of your estate, 3 things happen at once. First, it has to go through probate, the court process that inventories your assets, settles your debts, and only then distributes whatever's left to your heirs. Second, because it now sits inside the probate estate, it becomes exposed to your creditors' claims the same as any other asset you owned. Money that would have skipped past a named beneficiary entirely now sits in the pool. Your creditors can reach first. Third, and this is the piece that catches even careful families off guard, The IRS treats an estate as what it calls a non-designated beneficiary, and non-designated beneficiaries do not get a stretch. Here's the mechanism, straight from IRS Publication 590B. Say the account owner dies before what the IRS calls their required beginning date, generally age 73 for those born between 1951 and 1959, or 75 for those born in 1960 or later, and say no individual is named as beneficiary, so the estate becomes the beneficiary by default. The entire account then has to be emptied by December 31st of the year, containing the 5th anniversary of the death. Die in 2026 under those conditions, and every dollar in that IRA has to be out and taxed as ordinary income by the end of 2031. Compare that to a named individual beneficiary. Most get 10 years under the Secure Act's current rule to empty the account, twice as long, with real flexibility on timing inside that window. A surviving spouse or another so-called eligible designated beneficiary, like a minor child or someone close in age to the owner, can have even more favorable options, including stretching distributions over their own life expectancy. The 5-year clock is specifically what happens when nobody is named at all, the worst outcome on the shelf, not the default for every heir. And if the owner had already passed their required beginning date when they died, the estate skips the 5-year rule entirely and switches to a different schedule. Distributions have to continue at least as fast as the deceased owner's own remaining life expectancy would have required, a calendar built around an already older person's numbers, not a longer-living spouse's or child's. Depending on the owner's age at death, that can run shorter or longer than 5 years, but either way, once the estate is the beneficiary, there is no spouse-style reset and far less flexibility than a named individual gets. The account gets forced out of the family on someone else's timeline and taxed on it instead of yours. And here's the cruelest part for a surviving spouse specifically, on an IRA or a payable-on-death bank account. Being married to the account owner does not put you first in line there. Only a beneficiary form does that. Without one, even a spouse who obviously would have inherited everything still has to wait for probate to run its course, often many months, sometimes over a year, depending on the state and the estate, before a single dollar of that account becomes accessible. That wait lands at exactly the moment funeral costs, bills, and daily expenses do not pause for a probate court's calendar. Employer 401ks work differently, and it's worth knowing precisely how. Federal pension law generally requires your spouse's written consent before you can name anyone else as the beneficiary, and many 401k plan documents default an unnamed account straight to the spouse automatically. That protection is real, but it lives only inside employer plans. It does not extend to your IRA, your life insurance policy, or your payable-on-death bank accounts, which is exactly why every form still needs its own check. Part 3. The ex-spouse who is still, legally, your beneficiary. Here's the failure that surprises even some attorneys. You divorce. Years pass. You remarry. Or you don't. And the whole time, your old 401k beneficiary form still carries your first spouse's name because updating it was never on anyone's divorce checklist. Most people assume the divorce itself handles this, that a decree ending the marriage automatically ends an ex-spouse's right to your retirement account. For some state-level, non-retirement assets, that can be true. But for employer plans governed by federal pension law, your 401k, a pension, employer-provided life insurance, it generally is not. In 2001, the Supreme Court decided a case called Egelhoff versus Egelhoff, and the ruling still controls this today. On an ERISA-governed plan, state laws that try to automatically strip an ex-spouse off a beneficiary form get overridden by federal law. The plan administrator generally has to pay whoever is actually named on the form on file, ex-spouse or not, unless that form was formally changed before the account owner died. This is where the confusion around a QDRO makes things worse, not better. A qualified domestic relations order, the court order used in a divorce to split a 401k or pension between spouses, handles the division of the account during the divorce itself. On its own, it does not update who inherits whatever is left in that account if the account owner dies later. That still comes down to the beneficiary form, unless the order or the plan's own records specifically address it. A QDRO and a beneficiary form are two separate documents, filed for two separate purposes, and completing one does nothing for the other by default. A divorcing couple can spend months and real money getting the QDRO exactly right, then never update the beneficiary form, leaving an ex-spouse legally entitled to every dollar left in the account. For IRAs specifically, which are not employer plans and sit outside that federal law, some states do have their own rule that automatically revokes an ex-spouse as beneficiary after a divorce. But that protection is inconsistent from state to state. Some narrow it, some void it entirely under conditions like a remarriage, and it is not something to rely on blindly. Relying on state law to fix this for you, instead of just fixing the form yourself, is a bet most people don't realize they're making. Quick gut check before Part 4. If you've been divorced and remarried even once, pause the video right here and go check that form. It takes less time than the rest of this video. Part 4. The transfer that erases the form nobody remembers signing. The second common failure has nothing to do with divorce. It happens the moment you consolidate accounts, roll a 401k from an old employer into an IRA, or simply move your account to a new bank or brokerage for better rates or lower fees. Here's what almost nobody is told when they do that. The new account is not the old account wearing a new label. Anytime you land at a new custodian with a brand new account number, it's opened fresh, and beneficiary designations generally do not travel with you. Some same institution retitlings carry the form over, but a move to a new custodian rarely does. The form you filled out at your old bank stays at your old bank, attached to an account that no longer holds any money. Unless you file a brand new beneficiary form the moment the new account opens, that account can sit for years, fully funded, entirely yours, with no beneficiary on record at all, and an account with no beneficiary on record lands right back in Part 2. The estate, probate, and that 5-year clock. This failure is dangerous because it feels like paperwork you already handled. You named a beneficiary once, and once only protects the account it was originally attached to. Every rollover, every transfer, every consolidation into a new institution resets that protection back to zero. Part 5. The 5-minute check that fixes all of it. The first check does not require a lawyer, a fee, or a rewritten will. Every custodian, your IRA provider, your 401k administrator, your life insurance company, your bank, lets you log in and pull up your current beneficiary designation in a few clicks. Do that today for every account you hold and check 3 things. Is a primary beneficiary actually named? Is a contingent beneficiary named? In case the primary doesn't survive you, and does every name on that list still reflect your life right now, not your life 20 years ago? If any of your accounts involve a trust, a minor child, a blended family, or a special needs heir, that first check is still worth doing today. But loop in an estate attorney before you finalize how the form is filled out, since those situations have rules of their own. Then build in the moments that should automatically trigger a recheck: a marriage, a divorce, a death in the family, the birth of a grandchild you want included. And this is the one almost everyone forgets. Anytime you roll over, transfer, or consolidate an account into a new one. Treat a new account number as a hard trigger to refile the form, every single time, with no exceptions. If there's one thing worth carrying away from all of this, it's this: the beneficiary form is the real will for this money. Not the document your attorney drafted. Not your best intentions about who should get what. The form. This is not financial advice and not legal advice either. Every account, every state's law, and every family's situation is different, so review your own beneficiary designations directly with each account custodian and loop in an estate attorney or a fiduciary financial advisor before you assume any of this is already handled in your own accounts. If this is the kind of check you're glad you caught before it mattered, hit like, subscribe for more of these, and drop the word forms in the comments if you want the follow-up checklist video. Curious how many of you find one that's out of date once you go look. Your final assignment is simple. Open one account right now, today, and confirm exactly who's named. Then do the next one tomorrow. See you next time.